This segment is sponsored by Michigan Auto Law. You know the old Christmas song, Grandma Got Run Over by a Reindeer? We've all giggled over those lyrics, but consider the hypothetical. Grandma is crossing the street and she really is run over by a reindeer who happens to be part of a modified sleigh that is motorized, has four wheels, and was designed to be operated on a public highway. So, what exactly are Grandma's rights? Does she have a claim of pain and suffering against Santa's insurance company? Well, here to sort it all out is Michigan auto law attorney Brandon Hewitt. Has she got a leg to stand on, Brandon?
Well, hopefully her leg is okay, but yeah. So there's gonna be a couple of claims here. So we thought we'd have a little fun this time around and just kind of explain, through Santa and that classic song, what your rights or what her rights would be through no fault and everything. So
Yeah.
yeah, let's get to it.
Yeah. What about no fault? She
Okay.
qualify for benefit?
Yeah. So obviously we need to make sure that the sleigh is a motor vehicle, right? So we're just gonna assume that it's got four wheels. It's designed to be operated on the highway. The first place she's going to look to are her no fault benefits, which covers her medical bills, right? And that's going to go through her own auto insurance, not Santa's insurance. Okay. So she's going to call her own insurance company. If she doesn't have her own insurance, she'll look to a resident relative who she lives with or a spouse, grandpa's insurance. But basically, you go through your own insurance. That's going to cover grandma's medical bills, somebody to take care of her, gas money to and from doctor's appointments, somebody to help around the house, all that kind of stuff, but that goes through her insurance.
Mm. What about pain and suffering compensation?
Okay, so we are definitely not in the business of suing Santa, but assuming that uh, she could have a potential pain and suffering case against Santa and his insurance company or the reindeer's insurance company as the drivers who was driving. Santa certainly owns the sleigh, so let's assume that it's Santa's insurance company. Grandma needs to prove essentially two things. Number one, that she wasn't at fault, right? That she was in a crosswalk, that she was, had the right of way, that Santa didn't, Santa was negligent in driving his sleigh and running her over. That's the first thing, right? She has to prove that she was not at fault for that pain and suffering claim. The second part is that grandma has to prove that she has what's called a serious impairment of a body function, basically, right, her legs. So she can't walk quite as well anymore. She can't do the things around the house. She can't come to those Christmas parties. She has to show that basically her life has changed significantly after the crash versus what it was like before the crash. If she can show those things, she could have a potential pain and suffering claim against Santa. Again, we're not going to sue the guy. We want to stay on the nice list.
Yeah, for sure. But what can grandma expect in terms of a settlement? A lot of money?
Well, if Santa is a Michigan resident, he's required to carry at least $250,000 in liability coverage. But if he's not a Michigan resident, he lives in the North Pole. What grandma should be carrying is her own coverage for uninsured or underinsured motorist coverage, which means that if Santa has less than $250,000 in liability coverage, grandma should be carrying underinsured motorist coverage of at least that much. We recommend actually an umbrella policy to make sure those limits are adequate on her own coverage so they can kick in case Santa doesn't have enough.
Now, this whole scenario had grandma in the crosswalk. What if she's not in the crosswalk?
Well, if she's not in the crosswalk, Santa's going to have a decent argument that he wasn't at fault. He was just busy delivering presents. He couldn't see her. Rudolph wasn't working that night, so his nose really couldn't lead the way as far as lighting up the streets. So grandma might be, without a pain and suffering claim. But that being said, our no fault law says that grandma still gets her medical bills covered through her own insurance, even if she was at fault. So remember that no fault means you go through your own insurance no matter what for your medical bills. Pain and suffering means you weren't at fault and you could possibly sue the negligent driver or owner of that vehicle.
Real quick, if grandma's driving her own vehicle, she's not on foot, what about all that?
Pretty much all the same. She's still going to go through her own car insurance. But again, the question of who was at fault is going to depend on, who ran that red light.
All right. Well, folks, if you have a messy legal situation that needs sorting out by an expert, you can call Michigan Auto Law at 833-411-MISH or visit michiganautolaw.com. Brandon, thanks so much.
All right. Thank you guys. Happy holidays.